where we speak with experts, leaders, and change makers about movements of social change that have transformed the landscape of Canada and the way we live our lives. We're speaking today about the Charter of Rights and Pierre Trudeau with a man who knew the former Prime Minister pretty well, his former senior policy advisor and principal secretary, Tom Axworthy.
The beginnings of the Charter of Rights, when Prime Minister Pierre Trudeau decided he wanted to finally bring this into fruition, could you let us be a fly on the wall of those discussions? What was inspiring his decision and his action to make this reality?
Well, I think you have to begin on why was there a need for a charter? Why did he think there was a need? And ultimately, the vast majority of Canadians thought that this was a good initiative to do. And that's because Canada is a tolerant place. Our record is better than most. But there have also been enough abuses in our history where the concept of rights had to be better protected. And that means that you have to define what a right is. So a right is a claim that you can make on somebody else which is impartially adjudicated. That is, a right is not a favor. A right doesn't depend on the goodwill of somebody. A right is something that you are given as an inherent aspect of being a man and a woman. This comes with our human personalities. And this is important because human rights are a major component of human liberty, because each of us have them. And if we have them and we assert them, we can assert them even against the most powerful. And that doesn't mean we win all the time, but it means we have a chance of winning. And therefore that's important, because in Canada we were generally a tolerant nation, but we've had enough abuses to show that sometimes in the middle of war or when political parties go off the deep end, the general civility of Canada and the devotion to human rights has sometimes been cashiered in. We can look at the rights of French Canadians to their language. Well, the Manitoba schools question in 1890 took them away. And a minority was abused by a majority. Japanese Canadians were rooted out from their homes because of the xenophobia that occurred during World War II. But what could they do? They were dependent on the goodwill of Parliament, the goodwill of the Prime Ministers of the day. That wasn't enough. In Quebec, Premier Duplessis used his power to take away the rights of religious minorities he didn't like the Jehovah's Witness. So I don't want to paint the Canadian history as only a history of abuse. There are also many achievements there. But there were certainly enough that the need to better protect the right of Canadians was thought to be, by Mr. Trudeau and many others, an important priority. And the debate largely occurred around about who, in this question of adjudication, when one had to adjudicate competing claims, because there are different rights and they contend, who would do that? Would it be Parliament with the parliamentary majority, or would it be a Supreme Court appointed by jurists? And so much of the debate over the Charter was about who finally, in the essence, is the best ultimate authority, a judiciary or politicians. And on that, much of the debate sprang. Now, when the idea of a specific charter really began to emerge in Canada, countries like the United States had had their Bill of Rights centuries before. In Canada, there are many people who have contributed to the concept. One of them was a contemporary of Mr. Trudeau's Frank Scott, a very well-known professor, jurist, poet actually, in Quebec, who began writing about a charter in the 1950s. He leaned toward the CCF and the NDP, so that this view of rights was not any one party. It was shared by Canadians from all parties. Next, I would say the next important actor was John Diefenbaker, a conservative. So Mr. Diefenbaker brought in a bill, the Charter of Rights, in our Parliament, but not in our Constitution, which meant that it could be overturned by other parliaments. That issue of who was supreme to judge the judiciary or Parliament wasn't settled. So along this time, that Mr. Trudeau, as a young man who was an activist in Quebec in the late 40s and the 1950s, saw the abuses of his government at the time, Mr. Duplessis, fought them in a magazine called City Livre, became a professor of law at the University of Montreal, and beginning in the 50s, Mr. Trudeau, as an academic, began to write on the need for a charter. So this idea of his was not something that he came to as Prime Minister. This was the reason why he came into politics, to try to get this important change achieved.
So it played that big a role in his life.
I think it did in a very major way. That he became convinced that to complete the system of liberty in Canada, we needed to have a charter that was protected and adjudicated by the judiciary, because he personally lived in Quebec, led by a man who often usurped his power. And so every day, Mr. Trudeau would be seeing in Quebec examples of power untrammeled with Mr. Duplessis, and historically knew what had happened to Japanese Canadians, knew, he was passionate French Canadian, knew what had happened to his minority in Manitoba. So this became a very major part of his intellectual makeup. And then when he made the decision to no longer be a professor, but to become a politician, one of the first things he did when Mr. Pearson, he won the election in 1965, he became parliamentary secretary to Mr. Pearson. Mr. Pearson moved him up in the cabinet, making him Minister of Justice in 1967. And one of the first things that Mr. Trudeau did was to bring out an announcement that he and his government was going to work toward a Charter of Rights. Nobody would have been surprised. Anybody who had read Pierre Trudeau's writings from the 1950s in City Livre would have known that the first thing he would move on would be a charter. This is a very interesting example beyond the importance of the charter. I speak about it with my students all the time. That in Canada, or perhaps in most democracies, people think, well, what can I do to change? How can I change the system? The system's so big. I've got this idea, whether it be on employment insurance or the environment. I mean, what can we really do? Well, I often tell them, you know, when Pierre Trudeau and his friends began to talk about the charters, there were 3 or 4 of them in a basement. And they wrote articles about a magazine. And then they decided eventually to run for Parliament. And then when they ran for Parliament, they became ministers. And when an opening occurred, he became Prime Minister. But he came in with an agenda. He had an idea. This was not done for him on a briefing note by somebody. This is why politics can be very demanding, and one loses your privacy and a variety of other things. So you have to have, I think, good politicians have an animating idea that keeps them going in a very difficult life. There's no question that keeping Quebec in Confederation and expanding personal liberty in Canada through amendments to the Constitution that was the animating focus of Pierre Trudeau's life.
And yet there were challenges when he brought up the idea, right? There were quite a few challenges. And I read somewhere that you said it was debate revealed between people who didn't agree with it and those that did. Two compelling visions of Canada. One was a dream of nation building with individualism at its core, and one was province building with Parliament being supreme.
Mm-hmm.
So was that really the main struggle between two camps? Is that how you would sort of define it?
I think so, because the idea of a charter, of enshrining our rights, writing them, putting them in the Constitution, almost instantly was popular with Canadians. Now, it wouldn't be the number one issue that they would say. It was always the economy or healthcare or other things. But when the idea was put before Canadians, they'd say, yes, that was a very good idea. But there were opponents to it, very significant ones, and in particularly among the provinces, the provincial premiers, because Mr. Trudeau and his government, as Prime Minister, was willing to give to the courts and the Supreme Court the ultimate authority over rights, i.e. take it away from himself as Prime Minister, to say, no longer will I be the arbiter of this, it will in fact be in an independent judiciary. It was a diminution of prime ministerial power or governmental power, because Canadians could use the Charter to claim their rights, not to petition, to say, please, can I have my rights? No, you got to have Clayton Ruby or a lawyer go in front and say, her rights have been impinged, we demand justice. It's very different, but we demand justice to, please give me justice. So that was a diminution of political power in favor of a judicial interpretation and adjudication. But there were many politicians who were uneasy with giving that amount of interpretive power and adjudication power to the unelected judiciary. So there was a real debate around, held by honorable men and women on both sides of that debate. Where would our rights be most secured? Mr. Trudeau and those who supported him felt that ultimately the judiciary was a better ultimate defender, because we had so many examples of politicians for votes or whatever it is giving in to the temptations to abuse their power. And that, in my case, empirically or as a historian, there was no question where I felt the rights could be better protected. But there was a second line of a particular opposition as well in Canada. That debate that I just said would be held, it's still going on in the United Kingdom today, for example, about whether Parliament will be supreme or whether it will be the European Court of Justice. So that was a debate that politicians and jurists and others have had for many years, many generations. But there was a particular also debate that was peculiarly Canadian, and that's around language rights. Mm-hmm. Now, as I said, Mr. Trudeau, one of his animating forces was to have justice for all Canadians, but in particular for our French-speaking Canadians or minorities in general, English speakers in Quebec and French speakers elsewhere, because our history of minority rights protection around language was also not very good. So one of his positive approaches to persuading his fellow Quebecers that Canada was the place that should continue to be their home was that, yes, we've had these abuses in the past, but we are going to protect language rights, the ability to be taught in French, to live in French, to have represented in the federal government. We are going to protect those rights in the Constitution, and we're going to protect the rights of English-speaking Quebecers in the Constitution in Quebec. Wherever there's a politician who is thinking of using majority power to take away minority language rights, the Charter will be one of those things, will be an immense hurdle that politician will have to jump over, and the Charter may ultimately stop him or her from doing that. So, but the idea then of making language into a right, that was an expansion of the concept of rights. We know that liberty is a right, and equality of treatment is a right. Those are traditional political rights that we've had since the French Revolution, or the British Bill of Rights in 1689. But the addition in Canada to have language rights added to those rights, which Mr. Trudeau felt was essential because this is a country with 2 official languages and a good number of our fellow citizens were trying to leave it, that was a very important new addition to the architecture of rights to be added in the Canadian example. Now, in Canada, that also provoked much opposition. It provoked opposition from Quebec nationalists who didn't like the idea that English-speaking Quebecers' rights would be protected, because they were quite happy to potentially abuse English-speaking rights the way that French-speaking rights had been abused in Manitoba. So they were unhappy that it would be out of the political hands and put into the judicial hands. And similarly, many others in the rest of Canada were also had their doubts about the extension of the French language guarantees to the whole country through that provision. So, as well as the general debate over rights and who best to protect them and adjudicate them, we had a particular debate in Canada over the expansion of minority language rights. That was very much a Trudeau or a Canadian addition to the rights universe. And it's one that many countries now around the world look at our Canadian Charter because they also have language issues. In Ukraine, there's a debate between Ukrainian speakers or Russian-speaking Ukrainians. Well, lots of people are interested in our language protections now because a lot of new ground is broken in our charter.
Originally, was there supposed to be a referendum on the entire charter, and why did it not make it into referendum?
Well, these are some of the tactics and some of the actual process of building our charter. So, in our Constitution, prior to Mr. Trudeau, Canada was an independent country, but legally we were still a colony of Great Britain because it was the UK Parliament was the only body that could amend our Constitution. So Canada had kind of a constitutional anomaly because we Canadians couldn't agree on how to amend our Constitution. Britain didn't want to keep the power, it just stayed there because we in Canada couldn't agree what to do with it. And I think Canada had begun to look at how to amend our own Constitution in the 1920s. There had been many federal provincial meetings on how to achieve this objective, because when you get the premiers of all the provinces and the federal government, those are differing political jurisdictions, and it was very hard to get consensus or agreement among all of them that these changes should occur. So Canada's constitution was in stasis. Nothing happened on it until Pierre Trudeau came along and said, I want to make things happen. And so he began a process over many years. Remember, I said that he began writing about it in the 1950s. The government of Canada announced that it was going to move on a charter in 1967. We had the first federal provincial conferences on it in 1968, but many provinces didn't agree. And therefore, there it stood as well. So nothing also happened in Mr. Trudeau's premiership until having tried to do this for more than a decade. When he was returned to power in 1980, to be his last term, well, in this last term, he was going to try to get a charter. He was determined this would be all hands on deck to try to get this charter. And of course, preceding his return to power, we had, working on the charter, we had the 1980 Quebec referendum, which Mr. Trudeau had debated with Mr. Levesque, and Mr. Trudeau's side had won by about 60-40. So this was an important reason then to say, Quebecers have now said they want to stay. Now's the time to move on the charter and to get those language guarantees that Pierre Trudeau have been talking about for 25 years. Okay, so that's a bit of the political context. So therefore, Mr. Trudeau met again with the premiers, who then again didn't agree. So what Mr. Trudeau said and did, and this is what changed the dynamic, he said, all right, one last time, whether you agree or not, I am going to Britain, and we're going to have a Charter of Rights, and we're going to have an amendment formula. And we will ask the British to hold their nose and pass this Canadian piece of legislation one last time. Now, that was a whole different context than that the premiers then knew. They would either have to agree or Trudeau was going to go to the UK. And he had agreement from Mrs. Thatcher, though she was not a fan of the Charter per se, but she also recognized the anomaly of UK having the last power to amend Canada's constitution. So that was a very bold stroke, very controversial. But Trudeau said, we premiers and prime ministers have been talking about it, since the 1920s. We have to get on with this. So you can't have an omelet unless you break some eggs. So he broke some eggs of the convention that the premiers would all agree before there would be amendment. So he brought down a piece of legislation that would do that. That would be taken, passed by the Parliament of Canada, and then taken to the UK. Now, when he brought that down, then I want to emphasize this again, the other parties made some very useful amendments in the committees. That is, it wasn't just Trudeau-esque. The concept was, but many of the details were changed. And so there was really an all-party consensus. The Conservatives, NDP, and others made many useful changes to that constitution. So it really began to reflect a wide consensus among those who wanted to have a charter in the first place. There were still those diehards in the premiers who didn't want to have any charter. But the charter that we developed, there was like a first draft from Mr. Trudeau's government, and then a much improved one with everybody's input, right? So it was a much better document. Then we went to while that was going on, then the Supreme Court had to rule. And they ruled that what Mr. Trudeau was doing, again, you go to a court, they ruled that what he was doing was legal. Mm-hmm. He could go to Britain one last time, but what he was doing was unconventional. And that they, the court, wanted to have one last chance of seeing if the premiers, or enough of them, would come on side. Mm-hmm. So that the court really helped both sides, I suppose. Those of us who were in Mr. Trudeau's government were reassured that the court had said, yes, ultimately you can do what you said you're going to do. And but the opponents, or the premiers, the court had said, okay, men and women, get together here. There should be one last chance, or he's going to do it. So there was a tremendous incentive for them to come together. And so they did come together in the fall of 1981. And then there was an intense amount of bargaining. Now, you specifically asked about the referendum. The things that were being changed were both the charter, but were also an amendment formula, how to amend our constitution in the future. And Mr. Trudeau had included that there would be agreement on the provinces, but if there was not, we would have a referendum mechanism. That is, you would go back to the people to have a referendum on these kinds of changes. Now, again, those premiers who are worried or upset about the idea of a charter and the judiciary having this new sense of powers were even more worried that the people in a referendum would have the power to decide on a constitution rather than themselves. It was another one of our efforts to take powers away from politicians and give it to individuals. In one case, the vote; in the other, the charter. So there was tremendous opposition among the premiers who we met that one last time, and ultimately, after some very intense bargaining, a deal was struck. And what was the deal? The deal essentially was we will accept your Charter of Rights with a notwithstanding clause, but you accept our amendment formula, not the one that you proposed with a referendum. It was, when you got down to it, it was an old-fashioned political trade. We took the Alberta amending formula, and Mr. Lougheed and his colleagues took the Charter of Rights that Parliament had approved. It was a deal.
No one really came to their exact ideal place in the end. So notwithstanding clause was a big part of that, of the compromise on this end. And you've talked about the notwithstanding clause. You've mentioned is it the sort of Damocles or a paper tiger in an article that you wrote?
Sort of Damocles.
Damocles, right. So is that, how would you define that compromise, this notwithstanding clause, and what did Pierre Trudeau think about it? What do you think about it?
Well, the suggestion was that premiers would accept a charter, but they would have a right to also bring to their legislatures in areas around provincial responsibilities that, notwithstanding what the charter says, we are going to go against that provision by this piece of legislation. But it would, that wasn't a, that wouldn't stand forever, that if they brought that in, they would have to renew it. So it was a compromise. Mr. Trudeau did not like the idea of a notwithstanding clause because it went against the original idea I talked about, which is that human rights were inherent and had to be protected at all costs as adjudicated by a judiciary. What we came out with was that in practice that's what largely has occurred, but in theory provinces or premiers can still use the notwithstanding clause to say whatever it says in the charter, we will use our power to do this. But they will have to renew it. So it will be difficult to do. Now, soon after we brought in the charter, for example, Mr. Bourassa, there were tremendous debates over language rights within Quebec, used the notwithstanding clause in a way that many English-speaking Canadians felt impinged their rights. But he paid a real political price. There was a tremendous debate over it. So what has happened now de facto is in our Constitution, a province or Parliament can still, if they really think this is so important, they still have now the legal right that they can say, for a limited time, your charter right will not apply. But the use of it has been very rare, because if you take away somebody's charter rights, it suddenly elevates what might have been a minor issue into a front page issue, i.e. it's not done lightly. And it hasn't happened very often in Canada since. So at the time we didn't know how it would evolve. Theoretically, it doesn't jibe with Mr. Trudeau's vision, and Paul Martin, as Prime Minister, said that he would seek another amendment to take away that compromise that Trudeau had agreed to. But I think Mr. Trudeau, when he got down to it, was very sorry that he had to make that compromise. But he also knew without that compromise, there wouldn't have been the compromise over the charter. And in his heart of hearts, I think he was happy that he ultimately didn't have to go to Britain over the heads of the premiers. That it was better that we did have a consensus with the deal that we signed, even if it included a notwithstanding clause.
What do you think he'd feel today? What would he feel today? Where would he stand on the charter and its use? And
oh, I think he'd be enormously pleased and gratified by what has occurred. The charter has become an absolute essential instrument of every lawyer's toolkit. They look to see whether there are implications for the charter on the cases that are before them. Our courts have been very active and expansive in looking at what these measures meant in 1980 81, in the constitutional package that we brought out in 81 and 82, just to take one example, the provisions on the rights of Aboriginal peoples to have their rights respected on consultation and the duty to consult and so on. Those provisions, Section 35 and so on in the Charter. But our courts have taken those written provisions, Section 35, and interpreted them broadly, and have given our Aboriginal peoples a lot of scope on resource developments. That is, it's not just a dry piece of paper. Mm-hmm. It's being used on issue after issue. Now, there are some who still oppose the Charter and still oppose the rights of the courts to be as interpretive and the ultimate authority on it. But I, for one, who was part of the Charter, I've been gratified, delighted on the evolution of the judicial role in Canada. And were he with us today, Mr. Trudeau would be too.
Thank you for joining us today on the History of Social Change podcast. I'm your host, Elisa Birnbaum, publisher and editor of Sea Change magazine and producer of the History of Social Change project. Be sure to stay tuned as we discuss other social change movements that have transformed the landscape of Canada and the way we live our lives.